I will now call the next case on this morning's docket in the interest of KG, a minor child, case number 128535. Counsel, you may approach. And when you're ready, you may begin.
May it please the court, Richard Klein on behalf of the mother who's the appellant in this case. As a start point, I'll say that the Court of Appeals opinion in this case allows a district court to establish a permanent custodianship in a child in need of care case without a consent, without a finding of unfitness, and without termination of parental rights, all of which are required by code to establish a permanent custodianship.
I'm not sure I understand how that makes sense. That already occurred. That creation of a permanent custodianship, that already occurred with the mother's consent.
A prior permanent custodianship. But nowhere in the code does it say that you can subsequently establish another permanent custodianship or a substitute permanent custodianship, as the district court called it.
But here's my point, I guess. Once that permanent custodianship was created, mother's rights are now limited by statute, right?
Yes.
And the substitute order does not implicate any of mother's rights as they remained after that order got set up. I understand why the grandmother might have an interest in the substitution. Nothing about substituting the permanent custody impacts the remaining rights that the mother has after the first order. So I don't see how standing attaches here. She's got to have a stake in this fight, or in this order. It's not a fight, but this order for the substitute permanent custodianship. And that order doesn't affect any of the remaining rights that she had after the first order was entered.
Well, I think I'll start with, I think we're confusing a couple points, but I'll agree with that, except for one thing. I think the code creates a conundrum with the definition of parent. In KSA 382202 AA defines a parent as a guardian and every person who's liable to maintain, care for, or support the child. So the mother in this case is still a parent. Now, also, the permanent custodian is a parent. And I don't represent the grandmother in this case, but I don't see how you could possibly establish a new permanent custodianship without going through the steps in the code required to either get a consent from her or to find her unfit. But again, the code defines my client as a parent. And because she's a parent, still, her rights were never terminated. She consented to a prior permanent custodianship. And when there's a child in need of care adjudication to determine that the child is a child in need of care because of a failed permanent custodianship, and there was in this case, and the mother was noticed up, she entered a no contest statement that the district court accepted. She was treated like a parent up until that point. She considered consenting to a new permanent custodianship. And the minute she wouldn't consent to a new permanent custodianship, the rules all changed with her, and the district court, in essence, no longer considered her a parent. And that's the problem with the case. And so in the district court's memorandum decision, it said, the code does not specifically say what should happen following a child in need of care finding pursuant to KSA 38-2202 D13, which is a failed custodianship. So the district court looked at this as something different, and it's not. The code lays out what to do. And this court is acknowledged that numerous times. It's in order. You have a temporary custody hearing, you have an adjudication, you have disposition. And if you can't get to permanency with a parent, you find other ways to establish permanency, which is a motion to terminate parental rights. And that's not what happened in this case.
I want to ask you about the consent to the formation of a permanent custodianship. What is the scope of that consent? Not in this case factually, but under the law. Under the statute, when a parent enters a consent, I think it's under 38-2272.
Yes.
Right?
So
what is the scope of that consent as a matter of law?
The parent has to understand, and in this case, the district court, I think, at least verbally did everything it was supposed to do to make the parent understand that. I mean, it's laid out in 38-22 72D that a parent would still, or sorry, not
Isn't it F?
It's F, yes. I apologize. D is what a permanent custodian can do. And
So I guess I'll drill in a little bit and let you know what I'm thinking.
okay,
Is the scope to the creation of a general permanent custodianship, or is the scope of the consent to the creation of a specific permanent custodianship? In other words, the names of the people who will be the permanent custodian.
in this case, it was clearly a specific permanent custodian.
That happened in the record of this case, but I'm asking about the legal scope of the consent under the statute. Because this goes to whether or not, do you understand why I'm asking?
Yes.
I mean, if the legal scope of your consent is, I give my consent to permanent custodianship, and now it's completely out of your hands as to who is the permanent custodian. That seems to me to be a unresolved question, and one that when I look at the statute, I can't tell from the statute what the scope is.
I'm not sure I can either. I'll go down the hypothetical road, a road of which I like to travel. So let's say 10 years ago in Crawford County, mother had a child needed care case, and the state filed a motion to terminate parental rights, and she signed a relinquishment and filed it. And in the case, the father did really well after the motion to terminate parental rights was filed, and the child was reintegrated with the father. And then the father moved to Johnson County with the child. And the father passed away 10 years later. And in Johnson County, they filed a child needed care case. And the judge in that case said, well, he signed a relinquishment 10 years ago, so I'm still going to use that relinquishment. And we don't even need to file a motion to terminate parental rights. I'll just give the one and only consent to adoption to DCF in an order. Would we think that was okay? No. I mean, I think it's slightly different facts, but that's what happened here. The mother's still a parent according to the law. The statute's very, very clear. Now, just because there might be two sets of parents, I think that brings up some tough issues in a case like this.
Well, I may be oversimplifying this, but would you agree that had there not been a substitution of the permanent custodian, we would not be here today?
Yes. I think if
the only issue in this case is this substitution order and whether or not it's valid, and even kind of what it is.
Yes. The district court made up something that doesn't exist.
Well, and I guess my follow-up question is, do we is the scope of the consent the only thing that governs whether this is a real thing or not?
I don't think so. I think it's still
What else
that,
is, I mean, because if a permanent custodianship is like a legal shell, and it can be, you know, people can move in and out of that shell, then why couldn't the district court do this?
because the code doesn't.
Or is it specific to the person who is appointed as the permanent custodian? That's really what I'm asking. Is a permanent custodianship a status that can be filled by different people, different roles? Or is it something that adheres to a particular person?
Permanent custodianship applies to a specific person when that permanent custodianship is formed.
So if a
So when
permanent custodian dies, for example, the permanent custodianship dies along with them.
Yes,
And what would you point to in the statutes to get to that conclusion?
the definition of a child in need of care based on a failed custodianship. Because if there's a failed custodianship, the child can then be adjudicated as a child in need of care. And then that start point is.
Can you cite to me the statute that you're referring to in the sync code? I mean, I think I understand your argument. Your argument is the sync code says when there's a failed permanent custodianship, the custodianship itself dies, as I was putting it earlier. It goes away.
Yes, and I think that based on the definition, so 382202 D13, based on that definition, when there's a failed permanent custodianship, that custodianship, it doesn't, when a child's adjudicated a child in need of care based on a failed permanent custodianship, you have to go through the code. You have to, and the code tells
It's
you
like
how
a
to
reset, right?
The code tells you how to proceed. Yes, it's not, the district court considered this something different.
Do you know if there's any case law or statute that addresses what would be the much simpler factual scenario, I guess, of a permanent custodian dying?
No, and that's, I mean, this is a new question for the court.
If we, let me get down the road a little bit. What are you requesting us to do exactly?
My
What
request,
happens here if we adopt your position?
my request is that the Court of Appeals and district courts orders be reversed. And that the only direction I think this court needs.
The Court of Appeals never reached any of this.
They didn't because
so yeah, what do we do? I mean, yeah, to kind of step with me through the process. What ideally you're seeking from us? Should we adopt your position?
I think the only direction the district court needs is to follow the child in need of care code after an adjudication.
I want to talk about 382272H, which says, you know, if a permanent custodian is appointed, which one was, parents shall retain only the following rights and responsibilities. And it lists them. It says all other parental rights transfer to the permanent custodian. Right?
If I'll clarify, so 382272H says if there's a finding of parental unfitness, then those three rights remain. Above it lays out in 382272F, it lays out what I would say are all of the parental rights that remain when there's consent.
There was no finding of unfitness here.
There was no finding of unfitness in either child in need of care case, Crawford County or Johnson County.
But what rights that remained with your client after that permanent custodianship was set are implicated by the substitution of the permanent custodian?
I don't think any. But again,
So doesn't that affect standing?
I don't think so.
If you don't have an injury to any of your legal rights, you don't have standing.
She's a parent.
That's, well, that may be statutory, but it's not common law standing. You still have to have a cognizable injury caused by whatever it is that's there. I'm having trouble understanding why your client has a dog in the fight over the substitution of the permanent custodian. I understand why the grandmother does, because she's sitting there and she's got all those responsibilities and rights as a permanent custodian. But the mom's only got a limited universe of things that she has a legal right over, consenting to adoption or inheritance, that kind of thing. Where's the common law standing?
We're not in the common law. It's Child Need Care Code.
Well,
It's a statutory
in order to
creature.
have jurisdiction, you have to have standing. And you have to have statutory standing, you have to have common law standing.
But she clearly has standing. She's a parent.
With only limited rights. And I'm trying to implicate how the substitution of the permanent custodian implicates what rights are left after that permanent custodianship was created. And it seems to me the only way you get to where you want to get is to say, if there's going to be a substitution, the whole process has to rewind and start over again.
Yes, that's exactly what the code says.
Okay.
You would have to line through the word parent 500 times in the code.
There's a simpler way to get, I think, to what you're describing. And just to follow up on your exchange with Justice Biles, I think that we're probably all in agreement, you can correct me, that your argument is that the reason the limitation on rights contained in 2272F does not apply here is because the permanent custodianship went away.
Yes.
So 2272 doesn't even apply. Isn't that your argument?
Yes.
And so getting back to the way I put it, it's as though when there is a failure of the permanent custodian, as I put it, if the permanent custodian dies, the custodianship dies along with it. That's your position.
Yes.
That makes sense. Thank you.
Any other questions, colleagues?
I apologize for going over.
No, you're fine. Any other questions? Okay. Thank you, Mr. Cow.
Chief Justice, Your Honors, and may it please the court, Kendall Kaut for the plaintiff appellee. I think I'll start. I know we could go several directions with how the questions may go, but I'll start with Chief Justice Rosen, what you mentioned about, well, what happens down the road with each side's positions. And our position would be there's a way to sidestep all of these questions related to what happens if a permanency goes away, what happens with the rights of the parents, which would simply just be this appeal was raised to the Court of Appeals under the Sink statute, which limits appellate rights because there are only those 5 categories the legislature has prescribed. And as this court held in both 2014 and NRA NAC, and followed up with a very detailed discussion about the importance of stare decisis, why new members of the court would not change its opinion, from interest of NE, this is a post-disposition hearing, which fits in a post-permanency framework that is discussed in the interest of NE, which leaves no appellate relief under this framework.
Doesn't that beg all the key questions in this case?
I think there's a route where it could beg those questions, Justice Stiegel, but because it would just focus in this world on what is a post-disposition hearing.
You're assuming that it's post-disposition. I mean, that's my point. All of the key questions in this case ought to be asked and answered before we can decide jurisdiction. I mean, clearly, if you're correct, if the premises of your logical syllogism are true, you win. I mean, that's clear, unless we go back and change a lot of law. There isn't jurisdiction. But the key questions go to the validity of the premises, right? Not to the validity of the syllogism.
Well, I think that could be sufficient, Justice Stiegel. I think there's a way out of it. Maybe I don't persuade you on this point, but to lay out what the argument would be for how we can get outside of each of those syllogisms being necessary, it would be the framework from NRA NAC, which that case looked at an adoption that had gone on where someone's born in Sedgwick County in a really tough situation. The cousins want to step in and say, we have a familial relationship, so let us get the adoption. And in that case, the court said, we're not even going to take up this appeal because permanency orders arising from a post-termination permanency hearing. Now, I get your point, Justice Deal, which would be, well, that begs the question, and we're saying that this has to be a new permanency hearing because the original permanency is
have to address that to prevail on your jurisdictional claim.
I don't think we have to, but I would understand if you write an opinion that says, or if someone else on this court says, we just feel like it's still a new permanency hearing or a new disposition.
It doesn't matter what we feel. I mean, the question is, what is it? Because it strikes me that that's the live question here. Well, let me just ask it this way. Is there any such thing in Kansas statute as a substitution order in a permanency for a permanent custodian?
I would agree there is not a textual like D17 that says, here's what happens. Correct.
So don't we have to ask the kinds of questions I was asking your opposing counsel, which go to the, I guess I'll say, survivability of a permanent custodianship when the custodian fails?
I think, Justice Stiegel, if you disagree with me on the jurisdictional question, which...
No, I'm trying to answer the questions that come before we can resolve jurisdiction.
So I do think, and I want to make sure I answer that part of the question too. I do think it is possible, though, just to say the termination hearing that occurred in Crawford County in 2012, that is the disposition hearing. And a subsequent hearing about whether the permanency survives or does not is a post-disposition hearing because of how those two decisions I mentioned viewed what a disposition.
How can that possibly be? Are you suggesting that once there's one disposition hearing, there can never be another one?
There could potentially be other disposition hearings that would exist, but I'm saying that was the disposition.
If that disposition goes away, now we're back to square one. We're back to no disposition.
I think if it went back, as Mr. Klein is suggesting, to having the full sync process, then you'd be back in a dispositional process. But because Judge Sloan went this way, I'm saying I think that's a jurisdictional way out. I can respect, though, if you're saying we feel like it's got to be because there's not in the statute, it has to go that way, then I can transfer my arguments more to, if you go that direction, how are we going to view this next hearing for disposition and how should we view the survivability of a permanency? I'm happy to address those arguments too, if the jurisdictional ones are less persuasive for certain members of this court.
Well, so the position of the permanent thing, when you want to substitute, you have to start over again. The effect of that is to reinvest all of the parental rights that have already been disposed of in the earlier proceeding. You're going to reinvest the biological parents with all of their rights, even if it's 10 years later. You're going to reinvest them, and now you're going to relitigate all of that all over again. Is there any authority that exists for that position?
I don't believe there is, Justice Biles. And if it comes down to viewing how this court's viewed more recent sync cases, I really think all of the work that this court did in that interest of NE case shows that this court had said, look, a legislature can definitely be persuaded by some of the arguments Mr. Klein made that a parent just consents to one permanency. We're going to let you go ahead and have a new shot. If 10 years later you've changed your life, we've weighed the pros and cons. We're going to go that way. But in that interest of NE decision, the court went through a long discussion about we could also consider that one of the most important policy frameworks of the sync code is the need for permanency for the child and the threat that can happen to the child's health and welfare if they have to be reintroduced to a parent that, as in this case, the mother's attorney admitted hadn't had any interaction with the child in 8 or 9 years. And so I think that's a way to read the statute together. And if we're probably going to have to turn to the canons of statutory construction, if this court feels like it's necessary to go that syllogism route that Justice Stiegel had discussed, I think reading it in pari materia, which was also flagged as an important canon of statutory construction, because of the importance of having some finality in the sync code, that's a path as well.
Does my earlier discussion about the legal scope of the consent matter in your view?
It does not in this case, Justice Stiegel, because our position would be once you consent to a permanency, you've consented to a...
So you're answering my question. Yes, that you're describing the scope of the consent. You're saying that that matters. In other words, your position is this is a broad, the scope is broad and it's to the conservatorship, not to the conservator.
Yes, Justice Siegel. So it matters.
You have no right to complain when the conservator, and maybe that's the wrong word, the custodian is changed. I mean, because you gave a consent to a custodianship.
For the purpose of that question, Justice Siegel, I agree. It matters about how it's viewed. I thought your question was more about, does it matter what the explicit consent is in sort of a contract law? I'm saying it doesn't get into those principles. It's just, you are out of luck.
It's broad, because your argument is the legal scope of consent under 20, whatever the statute is, sorry.
I have several up here too, so I respect that.
2202, I think. That is a broad consent to the custodianship. Getting my words confused, right? It could be, though, that the consent is more limited to particular custodians, right? I mean, that's also possible.
Yeah, I understand, Justice Siegel, certainly within the Overton window of arguments, that would be an argument that could be
Okay,
advanced.
so then with that said, in this case, on the record, the consent given was clearly to particular people, to the custodians, right?
Yeah, without question, Justice Siegel.
And so even if the scope of the legal consent is broad, does that give rise to some kind of a due process problem? Or in other words, this mom, in her mind, understood that the consent was limited to the named custodians. And it feels like, I'm trying to sort of put myself in the shoes of that party here. It might feel like the rug got pulled out from underneath her. Hey, I only consented to these people, and now you're switching up on me. Does that create any concern in your view?
It could, Justice Siegel, and I think probably our two responses would be, unfortunately for the parties, they should have raised a due process issue if they wanted the court to consider it. And second, as the Court of Appeals acknowledged in its last paragraph, this result may seem harsh, but the legislature has not chosen to step in like it did in 2006 when it added parental unfitness as a category. So in two of the three ways you get to permanency, whether it be termination of parental rights or unfitness, the parent would always have a right to appeal because those are two of the 5 orders that can be appealed. But because in this case it's consent, it doesn't happen. I do empathize, Justice Siegel. I try to always think about what happens when the parties, when I'm not having a rap case in front of this court on the way to Topeka. And so in this instance, I do empathize. I think there could be a due process claim, but I think the obligation would then be on the party to raise that issue. And because it's not been raised, not before the court today, unfortunately can't be an issue they'd raise. We'd brief it in depth and see, but I think that obligation would be on them. And if you're going to rely on a statute that provides narrow appellate rights, you can't come up and then raise that issue for the first time in an oral argument would be our position.
What do you think happens when a permanent custodian dies?
Generally, Justice Siegel, I would say similar to what happened in this situation, the court should have a hearing and consider who should be the new permanent custodian.
And do we have any case law? Can you point to any case that says that's the correct procedure?
I cannot. I was trying to do pretty in-depth.
Can you point to any statutory subsection that says that's the correct procedure?
I think there would be no specific one. The most analogous one.
Not there, right? I mean, this was a made-up process.
It is
a struggle I have with what happened here.
I think it's maybe one of the more similar things, since we're trying to look at what could be analogous, is when the legislature created the self-defense immunity statute, there really wasn't a process for how exactly should a court go through and figure out when does this attach? Should you have it at the preliminary hearing? What are the
alternative argument is, wait a second, the legislature actually did articulate what should happen. They said that this child is now a sink. This is a sink case. That's
Sure.
what they said.
So, Justice Siegel, I don't think those are mutually exclusive. I think you can say, as our position would be, it's a sink case. But when we talk about what syllogisms are necessary for success, if the permanent custodianship exists in perpetuity minus something else, then it would just transfer to somebody else. But I do get that it would be nice if the legislature had added a D17 to clarify these scenarios. And so we're all trying to read in. We can empathize with Judge Sloan and her position. But ours would be, since the statute does contemplate if there's a divorce, it may go to one parent or the other. Death would be the most similar to divorce, and given the importance in pari materia has been placed as a canon of statutory construction by this court, that would be our argument for advancing that position.
Is there a reason, though, not to? So you got the problem with the grandma. So you're with your permanent custodian. Now you've got a sink case. But the sink case is it seems to me, is in the context of the permanent custodian being in loco parentis, which the statute clearly says that's what is here. It's the sink case in the context of the grandmother in this case, not a relitigation of the parents' rights, which were already disposed of in the first, other than what the statute has set out. To me, it all still seems to work. Now, is there something wrong with that notion from the state's perspective?
No, Justice Biles. I think that's very possible to go that route. I think the challenge with this appeal, compared to many that I've argued in front of this court, is there probably are 12 different ways you could reach different outcomes. But I think the Justice Biles suggestion of just saying, look, even if we're uncomfortable with the transfer, even if there isn't a D17 or whatever section would be added, you give up real rights. And it's even unclear what rights are even still ascribed to a parent in this situation where it's not an unfitness finding. And because those rights are so limited, and because you have allowed someone to step in loco parentis, and because even in that consent decree, the mother and father at the time might have thought, well, we feel really confident about grandma, so that's why we're consenting. Well, what ends up happening here is grandma doesn't keep the children because of some problems that develop. And then it sounds like the aunt doesn't let the mom see it as much. So there always is that risk that happens. But I am cognizant that a legislature may in the future decide we've weighed and balanced these arguments. Our viewpoint's a little different.
Would you agree with me just on the very basic proposition that if the law is that when a custodian fails, the custodianship fails, that there is jurisdiction in this case? I mean, there would have to be, right?
If the custodianship fails, and you would then probably have to go back and have a hearing, and then that subsequent hearing, I think, would attach jurisdiction because you'd have a finding of unfitness.
So once again, this case turns on that question. I'm trying to drill into what is the precise question in front of us. And it seems to me the question is, did this custodianship survive or not?
I think because of the nature of that hearing, Justice Stegall, there is a world, and the court may be uncomfortable finding it still, that would say this post-terminancy hearing was improper. You could give direction to district courts in the future to say not to do it, but the court could still say, although it was the wrong posture to do, because we never got to the unfitness finding, and because we never got to parental rights, and because the, unfortunately, mother did not raise a due process claim, there's just not that avenue to get to any of those things. So normally with your question, Justice Stegall, it would be hearing goes on.
I'm not even getting to the merits. I'm just purely asking about jurisdiction. Like another way to put the question is your jurisdictional claims are entirely premised on the ongoing viability of the custodianship.
In this particular case, not necessarily. I respect you may disagree with me, but it would be, even if that hearing should not have taken place and this court says the court erred at the district level, shouldn't have had it, that hearing that shouldn't have occurred could still be viewed as a post-disposition hearing where the result happened, which would leave no appellate rights. Now, the court, I think, would have some real due process concerns there. That's probably why that issue should have been raised. Now, I get, because really when we talk about what's the syllogism or what's the antecedent necessary, what would allow those appellate rights normally would be, you'd say the permanency doesn't survive, you'd go back and have the sync process, and then your appellate rights would happen from either termination of parental rights or finding of unfitness. And that's what gives you the appellate rights. But because in this process that didn't happen, there's no statutory way to appeal it would be our argument. And although, as the Court of Appeals recognized, that might seem a little unfair, I think this would give guidance in the future for someone to say, I'll raise a due process issue, let's litigate it out that way. Or a future district court could know, if this court clarified, in the future, we think these steps should be taken. That would be an avenue. Now, I get...
Well, district courts don't just get to do whatever they want and avoid appellate review because of the way they titled their ruling, right? I mean, the substance matters.
Substance undoubtedly matters, but I'm saying in this instance, it's a very narrow sync, obviously, is its own sort of ball game. Because that hearing would indeed be a post-disposition hearing where the wrong decision could have been made, that would still be the framing of it, versus normally, let's say we have a sentencing hearing where restitution screwed up, you would be able to appeal that because there's a direct appellate right for any criminal case. Here, that's the argument. And I think that's why the Court of Appeals was a little uncomfortable saying normally we would do that, but that's what happens here. And I can see I'm out of time if there are no additional questions.
Any other questions, colleagues? Thank you, Mr. Cow.
Thank you, Chief Justice.
Mr. Klein, you reserved 3 minutes.
I'll just make two quick points. One is, I think this court has jurisdiction. It typically takes jurisdiction when there's an authority to act question involved. And I think that's what we have. Did the district court have the authority to appoint a substitute, a substitute permanent custodian? That is the issue. And I will go back to one more time. I'll go back to the definition of a parent from 382202AA. And the legislator could have excluded a biological parent in that very easily. I mean, the definition is pretty clear. It includes a guardian and every person who's liable to maintain, care, or support the child. And it would have been very easy for the legislator to put a semicolon there and say, except for a parent who consented to a permanent custodianship. So my view and my client's view is that she was a parent. She should have been given the opportunity. A child need care finding is a reset, and she should have been given the opportunity to be treated like any other parent, according to the code.
Any other questions, colleagues? Do you have any further comment? Thank you, Mr.
No, Chief Justice. Thank you.
This matter will be taken under advisement